Good evening. I'm going to start the call to order the special meeting to the Oxnard City Council for January 25th, 2024. And item A, roll call and posting the agenda, Madam Clerk.
Councilmember Basua.
Here.
Councilmember Madrigal.
Here.
Councilmember Perello.
Here.
Councilmember Terran.
Here.
Councilmember Valenzuela.
Present.
Mayor Pro Tem McDonald.
Here.
Mayor Zaragoza.
Here.
Posting of the agenda. The agenda for this meeting was posted in the City Hall Bulletin Board on January 24th, 2024.
Thank you, Madam Clerk. Our next item is ceremonial opening, and we'll have the Pledge of Allegiance. Please help me, and Mayor Pro Tem, can you help me out with it?
Sure. Please rise and place your hand over your heart. Join me in saluting the flag of our nation by saying, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Mayor Pro Tem.
Okay.
Our next item is public comments.
Mr. Mayor, if I can make a
Let's
quick
go ahead.
request. In celebration of another lap around the sun completed by our city manager on today's date, I would like to sing happy birthday to him. So, just because it gets him so aggravated when we do
Las
this to him.
mañanitas al city manager. Go ahead. Happy
Happy
birthday to you. Happy birthday to you. Happy birthday, dear Alex. Happy birthday to you. Thank you.
Gracias y lo siento. Yo soy
Thank you, Mr.
viejo.
Mayor.
Happy birthday. Thank you. Okay, anyway, item C is public comments. This is comments only on this agenda item. During the special public meeting, public comments will be heard only on matters appearing on the agenda. The presiding officer will limit the calls, or the presentations to 3 minutes. So I just want to show we're only going to talk about this agendas here today. So we'll start off by calling some people that we have in this list. And Madam Clerk, I have Odette Moran, followed by Rudy Cortez.
Mayor Zaragoza, Odette, and Rudy is currently not available virtually or in person.
Okay, so we'll go to the next one is Jessica Sandoval, Joanne Morgan, and Real. Jessica Sandoval, followed by Jasmine Severi.
Mayor Zaragoza, Jessica is currently not available virtually or in person, and so the rest of the speakers on the list.
There are none of them here.
No, none of them are here.
But I'm going to call their names anyway. So Tracy Resendez, Terry Hayes, and Barbara Mackey-Ortiz are not available. So I'm going to continue then.
That's correct.
Thank you so much. So I have in person today, we had Maria Navarro. Maria Navarro, followed by Nicolar Ramos. Maria?
Good evening, everyone, City Council staff. In the course of the last 2 weeks, you have all become acquainted with the Via Oxnard tenant case. And you've taken direct action and immediate action to address their concerns. All evictions are traumatic, but evictions based on substantial remodel are especially heinous. People oftentimes feel desperate, hopeless, and intimidated. As you well know, there is virtually no affordable rentals out in the market, and families face displacement, overcrowding, or in some cases, homelessness. I feel here, standing with you, very honored to have gotten to know the tenants of Via Oxnard. And their humility, their strength, and their courage define them and have gotten them to this place now. You now have a choice. By approving these ordinances, you are, one, getting the choice to uphold the law that you helped pass, the law that has defined Oxnard tenant protections and made Oxnard the sixth city that has rent stabilization and these kinds of protections, the sixth largest city in California. And you are siding with the tenant families. You're siding with the people who are the backbone of our community. The majority of the folks here are farm workers. Over 200 people face displacement. All of the people here, everyone for except maybe 10 to 12 people live in those apartment units. Okay, so that's a lot of people. Half of the people that are at risk of displacement are children. And by that I mean minors. And there's a good population that are like 18 to 23, the grown babies, I guess. And so there are a lot of risks, and we don't want to downplay the situation. It is a very, very urgent situation, and that's why this ordinance and this urgency is needed. It's to protect their rights, to protect the ordinance that you helped craft and that you implemented. And just to be clear, the tenants have been super brave and courageous, and I've really appreciated the work of the housing department, of the city clerk, of the staff, of the city manager, of everyone here, because it has shown that you all do support and care for the people in this community. And I hope that city council does as well. So thank you.
Thank you. Nicanor Ramos. Señor Ramos, ¿en español? Sí. We'll have our translator come over. Ahorita va a llegar la señora para que nos oiga. Espera un momento, ¿eh?
Buenas tardes a todos.
Good evening.
Mi nombre es Nicanor Romero.
My name is Nicanor Romero.
Yo vivo en los apartamentos de Vía Oxnard
I live in the apartments on Via Oxnard,
y he vivido ahí desde hace 16 años.
and I've lived there for 16 years.
Recibimos una carta de desalojo
We received an eviction letter
de nuestros apartamentos para el día 16 de marzo.
for March 16th.
Les urjo que paren el desalojo
I please ask you to stop this eviction
mío y de mis vecinos en los apartamentos.
for
de
me
Vía
and my neighbors in the apartments of Via Oxnard.
Oxnard. Estoy deshabilitado.
I'm disabled.
Mi esposa y mis hijos trabajan para poder pagar la renta.
My wife and my children work to be able to pay for the rent.
Protejan nuestras familias
Protect our families
de Vía Oxnard del desalojo.
from Via Oxnard from not being evicted.
Terminaremos viviendo en nuestros carros
We will end up living in our cars
o en la calle.
or in the streets.
Es la única opción que encontramos.
Is the only option we see.
Por eso es importante
That's why it's important
que paren estos desalojos,
to stop these evictions,
ya que la ley aquí está para
as
ayudarnos,
the law is here to help us
para proteger estos casos
to protect these cases,
como los nuestros. Por eso les pido que
like our
voten
cases. That's why I'm asking you to vote
a favor de parar los desalojos,
in favor of stopping the evictions,
que toda nuestra familia está súper estresada.
because our family is super stressed.
Están pidiendo ayuda en las escuelas
They're asking help at schools
con los intendentes o los manejadores para que les ayuden a
with the administrators so they can help us.
Muchas gracias.
Thank you.
Thank you. Juan Carlos Ortega, en español también. Okay.
Buenas.
Mi nombre es Juan Carlos Ortega. Bueno,
My name is Juan Carlos Ortegas. Good evening.
yo vivo en los apartamentos
I live in the apartments Via Oxnard
desde 2019.
since 2019.
Tengo 6 hijos.
I have 6 children,
Me llegó una carta para
and I received a letter
26 de febrero.
for eviction for the 16th of February.
Les pido por favor que paren los desalojos.
I ask you to please stop this,
El mío y el de mis vecinos.
mine and my neighbors.
Trabajo como Prolipero en una compañía.
¿Cómo qué?
Prolipero.
Oh, I work as a forklifter in a company.
Soy cabeza de familia y
I'm the head of the family,
tenía que trabajar 30 horas
and
para
I would have to work 30 hours
pagar otra renta.
to be able to pay another rent, which will be more expensive.
Mi esposa tenía que trabajar otros 20
My wife would have to work another extra 20 hours,
Pues necesitamos también pasar con nuestros hijos tiempo.
and we also have to spend time with our children.
Ya están teniendo problemas psicológicos
They're having psychological problems
por la preocupación de que nos quieren desalojar.
because they're concerned that we're being evicted.
Les pido por favor que
I ask you to please
paren los desalojos,
stop this.
ya que están para ayudarnos.
You're here to help us,
Y por favor, pues, a votar a favor.
and
para-
please vote to favor so we don't get evicted.
Pues sería todo y que Dios les bendiga.
That will be it, and God bless you.
Thank you. Okay, our next speaker is Stephanie Lopez. En español, Stephanie?
English?
Okay, thank you.
Good afternoon, everybody. My name is Stephanie Lopez. I live in the apartments via Oxnard, and I lived there for 12 years. We received an eviction notice on March 16, and I urge you guys to stop the eviction, and our neighbors as well, in the apartments in via Oxnard. We are a family who lives in our apartments. We work very hard to have our housing, and I cannot believe that we, who are people with jobs, are being evicted and will end our living in the streets. I think of my grandmother who is afraid to open the door. She lives with a fear that she will be told that we have to leave in the next days or a week. She opens the doors, and all they do is speak English. And those documents that they post on our walls or doors are in English. And those documents, she cannot even understand. I ask that all those papers are placed on the languages my mom, my brother, whatever, and our neighbors can understand. Via Oxnard has tenants that only speak Spanish or indigenous languages. This is why it's important that you stop this eviction, especially because there are laws that protect cases like ours. This is why I please ask you to stop these evictions and urge that our families are having a lot of stress. Kids as well having a lot of stress, asking help in their schools to stop these evictions. Thank you.
Thank you. Samuel Salazar. En español, Samuel? Okay, go ahead.
Buenas tardes a todos.
Good evening.
Soy Samuel Salazar.
I'm Samuel Salazar.
Yo vivo en los apartamentos de Vía Oxnard.
I live in the apartments via Oxnard.
He vivido ahí desde hace 7
I
años.
have lived there for 7 years,
Recibimos una carta
and we received a letter
para desalojar el 16 de marzo.
to be evicted for March 16th of 2024.
Les juro que paren
I urge you to stop this eviction,
y los vecinos
and my neighbors too,
en los apartamentos de Vía
in the apartments of Via Oxnard.
Tengo 12 años trabajando en la.
I've been working 12 years picking strawberries.
Vivo en Vía Oxnard, tengo 12 años trabajando en la presa. Si soy desalojado, tendré
If
que
I'm
llevar
evicted, I would have
a mi familia
to take my family to live in the streets
porque no hay opciones de renta disponibles
because there's no rents available. There's no option
que yo pueda pagar en estos momentos
that I can afford in these moments
para pagar una renta de $3,700.
to pay a rent of $3,700 a month.
Tendría que trabajar
I would have to work
trabajos de 16
2 works of 16 hours
por día para poder pagar
per day to be able to pay this rent,
solamente.
just for the rent.
Por eso es importante
That's why it's important
paren estos desalojos
to stop these evictions,
ya que la ley está aquí para proteger a los
as the law is here to protect
como los de nuestro.
cases like ours.
Por favor, voten a favor de pagar
Please
por
vote on favor to stop evictions. Thank you.
Thank you. Okay, Margarita Martinez. Okay.
Good evening. I'm Margarita Martinez. I live in the apartments via Oxnard, and I have lived there for 19 years. We received a letter to leave the place, to be evicted, on March 16th. I urge you to stop my eviction and my neighbors in the apartments of Via Oxnard. We are a family living in the apartment. My husband is the one who works. This that's happening to us, we thought that this would never happen to us. We saw how our neighbors received eviction letters, but now we receive one too. And since that day, I had to accept that it's for everybody who lives in Via Oxnard that they're evicting us. My children every day ask me if we're going to have a place where to live. My husband and I have not slept for nights, thinking that as much as we look for, there's no place to go. And when I talk to my neighbors, they're receiving letters too. That's why it is important to stop these evictions that are causing emotional problems to our families and our neighbors, as the law is here to protect these cases like ours that are being evicted. Please vote on favor to stop these evictions. Thank you.
Yeah, thank you. Maria Santillano?
Good evening. My name is Maria Santillan. I live in the apartments via Oxnard. I have lived there for 15 years, and we received a letter to be evicted on March 16th of 2024. I urge you to please stop my eviction and my neighbors. The apartments via Oxnard. I'm a housewife, and the only person who works in this home is my husband, Ramiro Torres, and it's just him and myself in this apartment. We are elder people, and if we are evicted, we will end up in the streets or living in our car. That's why it's important to stop these evictions, as the law is here to protect the cases like ours. Please, I ask you to vote on favor to stop these evictions. Thank you.
Thank you. Okay, Juan Villa? Okay. Thank you, Juan. Mm-hmm.
Hello, City Council. So I just want to ask you guys to take some time and just think about all the people that are here. Everybody's gathered here in a very peaceful way to come and ask you guys to help them out. I have a father that works a lot of, most of the day. He unfortunately started crying the other day, and my son got to see that stuff as well. So it makes me feel very terrible that my dad's going through all of this. I just urge you guys to take a minute and really think about what's going on. Put yourselves in their shoes. I'm sure nobody here would like to see their fathers getting evicted from their home, especially when they've been there for over 13 years. My parents pay about $1,800 a month, so the dramatic change to $3,600 is about double the amount of rent. It'd be close to impossible for them to even pay anything like that. So just take some time and please think about that when you guys vote. And thank you guys for putting yourselves in the agenda for all of us.
Thank you. Madam Clerk, do we have any other speakers on this item, either virtually or in person?
Mayor Zaragoza, yes, there's one virtual speaker. It's with caller phone number ending in 6377. Please press *6 to unmute, and you have 3 minutes.
Okay.
Hello.
Hello? We can hear you.
Hi. Thank you. My name is Manuel Herrera, the creator of Citizens for Better Oxnard. I wanted to thank the city council, city staff, and the city manager for taking on this issue and for marking it urgent, because at the end of the day, obviously you guys are all here to help the residents of Oxnard. So for you to take this on and do what you can, it's commendable. So thank you so much for that. I also wanted to thank Cause for bringing this to the forefront, as well as the people, to show that the power of the people does make a difference, and for them to show up in force and ask for your help, and then for you guys to take the initiative to, again, mark this urgent is commendable. So just wanted to say that, just wanted to point that out. I know there's only so much you can do within the law, but hopefully you will do everything you can to protect the residents. So again, thank you so much for that. Y a todos quería decir muchas gracias por venir a esta junta y para enseñar que juntándonos todos puede enseñar que sí se puede. So buena suerte y gracias. Thank you very much.
Thank you. Madam Clerk, any other speakers virtually or in person?
Mayor Zaragoza, there's no additional speakers virtually or in person for this item.
Okay, so then we're going to go into item D1, reports. This is a report of City Attorney Department, subject no fault, just cause eviction ordinances. A recommendation that the City Council, number 1, adopt an urgency ordinance titled, an urgency ordinance of the City Council of the City of Oxnard amending Section 27-4 of the Oxnard City Council Code regarding no fault, just cause evictions occurring as a result of a demolition or substantial remodel. Number 2, approve the first reading by title only and waive any further reading of that ordinance titled, an ordinance of the City Council, City of Oxnard, amending Section 27-4 of the Oxnard City Council regarding the no fault, just cause eviction occurring as a result of the demolition or substantial remodel. Number 3, find that this ordinance is not subject to the California Environmental Act, CEQA, under the CEQA guidelines, Section 15060. C2 is that this ordinance will not result in a direct or reasonable foreseeable indirect physical change in the environment and any further or independently exempt from CEQA pursuant to Section 15061B3, and that it can be seen with certainty that there's no possibility that this ordinance will have any significant effect on the environment. And just for information, this was required by Measure M, a pre-recorded presentation, and we do have the City Attorney, Mr. Fisher, or his assistants to give us additional information before we deliberate.
Thank you, Mayor. So I would like to invite Deputy City Attorney Jason Zaragoza up to the podium. He has additional information about the ordinances before you tonight and can answer questions that you may have.
Jason, before we continue, Councilmember Perello.
I would just like to share that I have had ex parte communication with individuals on this matter.
You did ex parte, Councilmember.
Yes, I also had ex parte notification conversations with individuals on this matter.
Mayor Pro Tem.
I've also had discussions.
I also had discussions, just for information, with some of the individuals.
I also have had discussions.
Councilmember?
I have not.
None. Councilman Turan?
Thank you. I did have a
2 phone meetings with cause over this. Thank you.
Thank you. Oh, Jason? Good, thank you.
Good evening, Mayor, Mayor Pro Tem, members of the council, Deputy City Attorney Jason Zaragoza. Is it possible to pull up the slideshow? I know we haven't been doing these typically, but I thought it important to provide a brief overview of what's before you tonight. Tonight we'll be presenting 2 ordinances. One of them is an urgency ordinance. The other is a standard ordinance, both addressing no-fault just cause evictions with regard to substantial remodel as the basis for that eviction. All right, so recommendations before you tonight. 1, to adopt the urgency ordinance, amending the city code regarding evictions resulting from a demolition or substantial remodel. And then 2 is to approve the first reading, or essentially introduce the general ordinance or the regular ordinance that does the same thing. Important to note on this one, the urgency ordinance, if adopted, would require, well, first it requires 4/5 of vote of the council, which means 6 affirmative votes. Secondly, it would be effective immediately upon adoption if you do go forward with adopting the urgency ordinance. Whereas the standard ordinance would be introduced tonight, brought back to you at another meeting, and if adopted, be effective 30 days thereafter. Okay, so a lot of text. You don't have to read it all, but under existing regulations, owners of residential real property may not terminate a tenancy for just cause, subject to certain exceptions, and one exception is to perform a substantial remodel. So what is a substantial remodel and what is not a substantial remodel? So important to note up here that the substantial remodel is the replacement or substantial modification of any structural and electrical, plumbing, or mechanical system that requires a permit from a government agency. And then the last bit there, it's something that can't reasonably be accomplished in a safe manner with the tenant in place, and that requires the tenant to vacate the residential real property for at least 30 days. What is not a substantial remodel are sort of cosmetic things. If you're just painting or ripping out some carpet or something, doesn't require a permit, would not qualify as a substantial remodel. Okay, so AB 1482, if you recall, is the Tenant Protection Act that provided for no-fault, just cause eviction, tenant protections, and then you adopted tenant protection ordinance that expounded on that or provided for greater protections. So the substantial remodel aspect of the Tenant Protection Act is mirrored in our current city code. And then I also wanted to point out that there is also SB 567. Thank you, Councilmember Valenzuela. In the staff report is referred to as AB Assembly Bill 567. That'll become effective April 1 of this year. However, given that the Tenant Protection Act allows for greater protections to be imposed, there's no need to wait until April 1st to propose the regulations that are before you tonight. The urgency ordinance, actually that's not here. Okay, so state law allows for the city to adopt additional protections, things that are more protective than the provisions of 1482. So if adopted, these are the things that would be required under the new regulations. So a statement informing the tenant of the owner's intent to demolish the property or substantially remodel the rental property. And then there's a specific statement that has to be included in the notice as well. And the point to highlight there is that the owner must offer the opportunity to re-rent the unit with the rental agreement containing the same terms as the most recent rental agreement with the owner at the rental rate that was in effect at the time the tenant vacated, if the substantial remodel is not commenced. And then this is sort of the big one at section 3 here, which is if you're going to provide notice of termination of tenancy because you're doing a substantial remodel, you'll have to, the property owner will have to have a copy of the issued permit or permits required to undertake that substantial remodel. And if the remodel doesn't require a permit, they'd have to show proof of a signed contract with the contractor hired to complete the work. So again, as existing law would not necessarily require proof that permits have actually been acquired, whereas the new regulations would. The whole premise here is simple. If you're going to evict a tenant for a substantial remodel, that being the purpose, then you should have to actually take affirmative steps toward that substantial remodel as opposed to utilizing it as a basis for a no-fault just cause eviction. The non-urgency version of the ordinance, again, same provisions that are in the urgency ordinance, and it's really just a timing thing of when that would go into effect, right? So it'd be introduced tonight, brought back to you for adoption, and then effective 30 days after that.
So Jason, before I go to Mayor Pro Tem, I've read in one of the ordinances that, for example, if it's a building is going out for a substantial remodel, and so that person is being displaced at that time, and after 6 months, they can come back and potentially utilize the same building?
So they would have the opportunity, the right of first refusal to re-enter that unit.
And also, for example, if where does the 60-day come up with individuals that have been in a home for over a year?
So if you've been a tenant at the property for at least a year, then 60-day notice would be required in order to.
1 year is 30 days, and the over a year is
2 years. Yeah. Yeah. 60-day notice.
60 days.
Yeah.
Okay, and of course then I think I also saw that a major demolition is something that has to probably replace multiple heating, plumbing, et cetera, as opposed to just painting the building and replacing the carpet and those kind of things.
Yeah, so the substantial remodel, essentially something that would require you to get a permit from the city. Yeah, versus just, again, painting or, some of those
It
minor
requires a permit, and the big
issues.
one, and then if it's a big project, the tenants have to move out tentatively.
If they can't if the property owner cannot perform the work within a 30-day period while the tenant remains in the property, then yes.
Thank you. Mayor Pro Tem.
I think that was Valenzuela's ahead of me.
Oh, let me see, number 2, I thought, okay, Valenzuela.
Thank you, Mayor Pro Tem. Yes, quick first question actually I have is, so if we move to do this an urgency ordinance, we don't have to vote on the second recommendation, that's correct? Or is it automatically adopted?
So the urgency ordinance would be adopted, would be effective immediately. The ordinance, the standard ordinance, you would still take a vote on, and then that would still come back to you for adoption. So you've got both of them. One of them is effective immediately. The other would not be effective until 30 days after adoption. But it's standard practice to move forward with both of them simultaneously.
All right. Thank you so much. Yeah, I just wanted to state thank you all very much for the speakers that came out here, all the tenants from the Via Apartments and other folks who came to speak. This, as the first speaker said, this is a traumatic experience for a lot of individuals. With the threat of losing their home, they've been there for multiple years, and the potential to come back with increased rent price. I'm very sympathetic towards their cause, and ultimately, I think, we see the cost of housing in the Central Coast rising every month, and is pushing families out of here into the Central Valley and other parts of California, out of the state. And ultimately, I would be very supportive if we could make this passes as an urgent ordinance, and as I would move that we adopt the recommendation. Thank you.
Thank you, Mayor Pro Tem.
Thank you, Mr. Mayor. I have to be honest, I struggled with this a little bit in reviewing it and deciding how I would approach it. And in looking at other communities throughout the state of California that have enacted rent control ordinances, sometimes you will see that there seems to be an artificial inflation in rents based upon the incremental amounts that they can raise it each year, where it wasn't always happening that way to begin with. So I think that's detrimental to the renters. That being said, I also have a little bit of heartburn with the term substantial remodel or substantial renovation as being somewhat on the vague side. And I could probably line up 10 people and ask them, what is substantial remodel or substantial renovation, and get 10 different responses. That's just the way of the world sometimes. So this body enacted rent control about 18 months ago, I believe, somewhere around there. And so as far as I'm concerned that it was enacted, I think we have an obligation to follow the rules that we enacted and make sure that they're adhered to. So what our ordinance is doing now is tightening up that substantial remodel or substantial renovation element to make it a little more tangible in terms of what does that include. And I've seen it happen in Ventura, I believe previously in Oxnard, and not every landlord does this. But I think have been some landlords that use the vagueness of that term to do what they call a substantial renovation or remodel to get their property lease temporarily out of rent control to be able to do whatever. And I'm not a big fan of trying to interfere with people's ownership rights or how they deal with their property or anything else on the governmental side. But the ordinance was enacted by this city. It is the law. And I expect that if people agree with it or not agree with it, that they abide by the law as enacted by their elected representatives. That's the way this whole system works. And if you're not going to abide by those laws, then why have a legislative body that enacts something that gets completely ignored? So that's what's created the quandary for me. I think that in today's day and age, when you look at the available rental material that's out there, it is a very limited supply, very limited, and it's very expensive. And I think that the loss of living quarters at a reasonable rate currently would put people at a disadvantage, especially when they try and find somewhere else to go to. And we're seeing this with some of the people from Brookside that have been temporarily displaced due to the natural disaster, the 100-year flood or the 10,000-year flood rainstorm. They're having trouble finding places to go to, even on a temporary basis. So that the need is real. The opportunity to fix this is real. I think we as a city have an obligation to try and protect our residents as much as possible without being too onerous. And I think that's going to require us to enact this ordinance on both the emergency level and the regular level. And that being said, I will be supporting this tonight on both approaches. Thank you, Mr. Mayor.
Councilman Turan.
Thank you, Mayor. And thank you, Mr. Zaragoza, for the information. And I'm glad that the public was able to see it live tonight if they did not have the ability to preview it ahead of this meeting on their own time. I have a couple of questions just for clarification. In reviewing the definition of a substantial remodel, maybe would it be helpful if we put the slide back up? Can we do that? Where we have the definition of what a substantial remodel looks like under this.
It's up.
Okay. So when we look at the definition here of a substantial remodel, we have a number of examples listed there, and I think it's important to point out what this also does not mean, as stated elsewhere in the presentation. Cosmetic things, right? But in a substantial remodel, let's say that just carpeting and painting is done. Purely cosmetic, no permit required for those, to my knowledge. That would not be considered substantial work, right?
Likely not. The substantial remodel would require the tenant to vacate the property for at least 30 consecutive days.
At least 30 days.
And a permit too. It requires to have a permit for a substantial
Yeah, it would require you to acquire a permit, yeah.
No, that's important because otherwise,
And I think, let's look at one unit. Recarpeting a unit, I would imagine, typically wouldn't require a permit, or it wouldn't require the vacation of the tenant for more than 30 days. So it wouldn't meet that definition of a substantial remodel, right?
Yeah.
Okay. Going one layer up, window replacement, that could require a permit, but again, could typically be done with a tenant in place, therefore wouldn't meet that definition. A landlord could not say, hey, I'm replacing the windows, I need you to leave, because it would have to be that type of work would require someone to not be there, which that may not be the case with windows, but also typically you wouldn't take more than 30 days to do that, even if the tenant had to leave, correct?
Certainly, that would be, on a case-by-case basis, you have to consider that, but generally, yeah, I mean, for 30 days, the tenant would have to be displaced.
Thank you. And I'm just trying to give us a sense here for what substantial remodel is not and wouldn't meet the definition here. So we couldn't evict people based on these. And then, of course, I was trying to think of an example of what would fall under this. I mean, I'm looking at removal of like load-bearing structures, studs, completely gutting a unit, and would take more than 30 days. That would fall under this definition, correct?
Correct. I mean, you need to acquire permits to do that and displace the tenant for presumably more than 30 consecutive days.
There's certainly a potential for that. Okay. So going down that path, now if this ordinance is to go through tonight, the urgency and the standard one, this would now require a landlord who feels that they are going to be doing a substantial remodel to provide notice, and then the tenant is evicted. But then if the work is not completed, as I understand this, the tenant has the option to return at the same lease terms prior to that eviction. Is that correct?
Is correct. Yep.
Okay. And the reason I'm asking this is I'm just trying to cover the base and have it clear on what this could look like in practice, what the requirement is, and we can bring the slide down if we want now. I appreciate having that back up. Having folks understand what this looks like in practice and what the obligation is of property managers and landlords in these situations. And a question I have, looking at the handout that we received in the presentation that was provided ahead of time, on slide 6, where it says a description of the remodel and the expected completion date, the second bullet states, if no permit is required, a signed contract with the contractor detailing the specific work to be undertaken. I know that was in tonight's presentation too. Just a question I have is, and maybe our community development director might be able to help with this too. Do we have an idea or an example of what that might look like? If no permit is required, a signed contract with a contractor detailing the work. What type of work in a unit might not require a permit, but would otherwise meet this definition?
Yeah, so that would be something like mold abatement. It's something to abate a hazardous nuisance that would not require a permit.
Okay, but presumably could take that amount of time and certainly couldn't be done with the tenant in place.
Could not be done with the tenant in place.
For safety reasons?
Yeah.
Okay. But in that case, they would still need to show proof. This is the work we're having done. Here's a signed contract with a contractor. Here's the expected completion date.
Yeah, correct. I mean, you'd have to show, the whole point here is to show that there's actually work that's attempted to be done, whether it's evidenced by the actual permit that's been issued to you or a contract that you'd entered into to perform the work to abate the hazard.
Okay, thank you. And just one last question on this. We certainly have language in here regarding if a tenant is evicted for what's called a substantial remodel, but then the work doesn't happen, they have the ability to come back.
Yep.
Does that also include, let's say that, and I don't want to get into hypotheticals here, but just so it's clear, if that happens, the tenant's evicted for what's called a substantial remodel, there's permits and work that's supposed to happen, work happens, but instead of what was listed in the substantial remodel ends up being just carpeting, painting, cosmetics. I mean, is there a mechanism? Is it on the tenants to report that to the city? How is that covered in that type of situation? When one thing is stated, but that's not what happens. Something less substantial happens.
Yeah, I mean, that would require a complaint to actually be filed so that we could investigate whether or not that is indeed the case. And if that is the case, then they'd be in violation of potentially multiple sections of our ordinance that we would then pursue actions on.
Okay.
Yep.
All right. Thank you very much. I appreciate your work on this and your responses.
Councilor Valenzuela, do you have any additional questions or before we go to Councilor Perella?
Actually, Bert couldn't go first because I already had a chance to speak.
Okay, thank you. Councilor Perella?
Thank you. I appreciate the people that have shown up, appreciate the questioning. Just some simple meat and potatoes questions. With respect to the notice, the last time that this issue came up to the council and tonight, we've needed translators. Are there requirements? As I recall, last time we needed a translator from Mixteco to Spanish and Spanish to English. Are there any requirements that any of these notices have to be in various languages? And is
Okay.
it the responsibility of the landlord to know which language they have to be in? Or do we put in multiple languages?
So the requirement that the notices had to be provided in multiple languages was a requirement that to notify the tenants of the existence of the tenant protection ordinance and rent stabilization ordinance that were adopted. Our city code requires that notices be provided in the same language that the lease is in. And if no lease, then in the same language that the lease terms were negotiated. That is the requirement. That tracks state law as well.
Thank you. With respect to some of the questions that Councilmember Turan asked, if there is work processing and there are permits required, what is the frequency, maybe Mr. Pengelly can answer, the frequency with which code or inspectors check this stuff so that if something is going to be drawn out over the length of time and now there may be changes in less work or more work required, putting the tenant's opportunity to take advantage of a situation in jeopardy? Is there an expediting process in specific cases having to do with this, that the inspectors come in and make sure the work is being done as requested by the applicant?
Mayor, Council, Jeff Pengelly, Director of Community Development. So the inspections are happen at certain construction milestones, and those inspections are requested by the contractor when they have completed certain stages of work and are ready for the inspection. So we would not be visiting on a set frequency. It would be up to their pace of work, depending on the size and scale of their project, when they would be ready for certain types of inspections.
If there was a window of only 30 days allowed for certain things to take place, do we make it a policy to get inside that window before the 30 days pass?
No, at this point we don't, but that could be something that we work with City Attorney's Office on in these cases when there's been a declaration of just cause eviction due to substantial remodel and a 30-day claim or a less than 30-day claim, whatever it may be. Currently, we respond to inspection requests when they are made.
And when we respond, I know that we are understaffed a little bit. When we respond, how long does it take to the response to occur?
Our inspection division has about a 99% or better next day inspection record.
That's a compliment. Thank you. That's a good deal.
Councilman, that's extremely important what you just said, because
it's impressive.
Under the urgency law, they're going to need that property, but I just want to thank you for sharing that.
With respect to some of the requests from some of the potential requests from some of the property owners, is there any favoritism shown because there are people, tenants at risk to get these permits through the process, through the hopper quicker than normal? I know that we have a process where if certain individuals want to get the permits, they can pay extra money to get it up front. Is there an opportunity for something special in situations like this? Maybe requiring a certain number of people involved, a certain number of units, or that it's a urgency case?
Just to clarify, at this point, we do not have a mechanism by which somebody can pay more money to get a faster path through the permitting process. We do segregate permits by the scale and size of the project, express, regular permits. We have specialized programs for certain types of tenant improvements, the small business assistance program, et cetera. That's the current process. Where there's a business or a resident that has some urgent situation or urgent circumstance, we frequently find ways to push them through the process based on some urgency and something unique about their project. But there isn't a class of projects that can walk in and say, we just are in a hurry. Time is money for everybody, and we push everyone as fast as we can. But sometimes there's, flood damage repairs or something like that where somebody needs to gain occupancy back in. We clearly take extra steps, work overtime, whatever we need to do in those extreme cases. But, those are, again, a case-by-case basis. It's not a normal path through our process.
Thank you very much for sharing that with the public and the council. One last question having to do with a question that was asked about carpet. If we're changing the carpet, we do not need a permit?
That's correct.
Okay, just a worst-case scenario.
For residential units, yes.
Residential, okay, worst-case scenario. The owner is going to change the carpet. He finds out that there's black mold under the carpet. And he also finds out that the floor, the base, is rotten. When he has now exposed that situation, what window, what class, what bucket does he fall into with having to give notice and make these repairs? As black mold is considered a very serious health issue.
Yeah, there could be also, it's not uncommon for older flooring materials to have asbestos in some of the mastics as well. There's, it's going to be a case-by-case basis and how big the problem is. A lot of times a simple plumbing repair to fix a leak in the wall means they discover the entire main stack through the whole building is corroded and falling apart. So a project can snowball into something that could morph into a substantial remodel without the owner knowing that up front. So they would have to come in, go through this process, obtain permits, and do the proper notices, assuming this ordinance is passed.
And we feel comfortable that if that process, in that particular case, the clock for the repair and the clock for giving notice to the tenant would be covered in this ordinance?
That's a little bit of a legal question rather than a permitting question. I think your question might be that if a project, maybe it's the timing of when they would come in and get a permit relative to this, or would we be judging whether or not their project will take more than 30 days reasonably or not? We would provide feedback to the city attorney if they received a complaint under this ordinance that somebody claimed that, hey, this is a simple construction repair. This shouldn't take more than 30 days, yet I've received an eviction notice for just cause saying this is going to take more than 30 days. That would be a complaint received, assuming this ordinance passes, by our city attorney's office or our housing department, and we would happily consult with them and give our professional opinions as to what why that scope of work would or would not fall into that stated time frame.
I think our assistant city attorney has an answer for you.
Thank you for those questions, and I appreciate that.
Yes, I'd like to follow up. I think it's important to note, if you look on page 11 of the staff report, which is the proposed new language, before the tenant can be given notice that they need to vacate because of substantial remodel, all these things have to happen first, including, if you go to the next page, the copies of the permits that have been issued. So to the extent that the permits have not been issued for the work that's done, the notice to vacate cannot be issued. So in this particular situation, if the issuance of the permits take a little bit of time, that means that the tenants cannot be evicted until those permits are pulled together and the notices are given.
Thank you very much, Mr. Rizal, for that clarification. I appreciate it. This is mostly for the city attorneys and possibly housing. What we are planning tonight, is it unique to this city and having not been done anywhere else in the state of California? Or are we simply copying something that has been successful somewhere else? I would equate this to walking out on ice. Nobody wants to walk out the first time the lake freezes over. They want to know when it's thick.
So, Councilmember Perlo, there are other agencies that have adopted ordinances that essentially codify what SB 567 are going to do, that will be state law requirements as of April 1st. So there are other agencies that have adopted tenant protections similar to these.
And have they withstood a challenge? Do we know if they've been challenged, and have they withstood a challenge?
I'm not familiar with any challenges.
Okay. Mayor, I believe those are all my questions.
Thank you. And I think,
thank you, staff.
Jason, I think you mentioned something too. That's coming up April 1, right, with the state?
Correct. So that is effective April 1st. However, under the 2019 law of the Tenant Protection Act, if a local ordinance is providing greater protections, tenant protections, then those are allowed under the law.
And we have the ability to do that.
And that's in part what these ordinances do.
That's important to understand. Follow up.
Apologize, Mayor. I have one more question. Tonight I heard, and the other night I heard dates given. Tonight I heard the date March 16th and February 15th. When was the earliest that these notices went to residents? Is there a spokesman that can address that? Because
maybe,
over a period of time,
Maria might have that information. I'm not sure if we,
and I'd appreciate it if you could address that. And the reason I asked that.
or Ramirez, do you have the information? Why don't we just have staff do that?
Good evening, Emilio Ramirez, Housing Director. I'm sorry, Councilman, I missed the entire question.
Okay, thank you. I appreciate your expertise and the work that you do for us, Mr. Ramirez. Emilio, there have been different dates given when people have been given notice of when they have to be gone, eviction notice. What is the dates that these letters were received? And the reason I ask that, it seems that this has happened all of a sudden, and yet these dates, there's a little bit of like a month gap. How long have these letters been in the hands of residents? And the reason I ask is, I believe it's 2 weeks ago was the first time this came to the attention of the full council. And whoever is marshaling these services, they had a real, in my opinion, and I'll let you answer the question if you can in a moment. If the house is on fire, you call the fire department. That's a city service. If there's a guy robbing your car, stealing something from your house, you call the cops. That's a city service. If something like this is happening, you call the city. It's a city service to get you an answer. Is there any advice that we can give to any organizations, possibly cause specifically, to get it to us ASAP so that we can help them help us to make something work for the residents?
Thank you, Councilman. First of all, I'd like to say that these are existing in open cases with open investigations. So I want to be careful about the detail that I offer.
Then right off the bat, to avoid, I want to know what you can say. Right off the bat, to avoiding litigation or getting our city in hot water, I'll retract whatever it is that you think I shouldn't ask. And I appreciate your candor.
Let me answer. There has been notices given to different tenants from the same landlord in the same complex over the period of the past 3 or 4 months at various levels, at various occasions. I think that you're absolutely correct, sir. If whoever has notice, we need to receive that complaint from the complainant as soon as possible so that we can initiate that investigation. Whether that's the tenant directly or the landlord or any person in the community, we definitely need to know as soon as possible so that we can start as quickly as we can.
Thank you very much. I appreciate your response and thank you for your work.
Thank you.
Thank you. Thank you. Councilman Sue, you have some comments?
I have comments. I don't have any questions at all.
Go ahead.
So and I'm going to say my comments in Spanish first. Les quiero dar las gracias a todos los que vinieron hoy esta noche a hablar con nosotros. Gracias por su valentía. Yo sé que muchos de ustedes tienen miedo de lo que va a pasar y no vinieron a decirnos antes por ese miedo. Y les quiero agradecer su valentía y decirles que aquí es un lugar que ustedes pueden venir sin miedo. A lo mejor no vamos a tener todas las respuestas que ustedes necesitan o a lo mejor no les vamos a poder ayudar, pero siempre vamos a tratar de ser honestos con ustedes y espero que lo que vamos a hacer hoy les traiga por poquito consuelo y puedan, aunque sea, dormir esta noche. Y les quiero dar las gracias por estar aquí.
And in English?
Oh, man, Mayor.
Come on. 25 words or less. Go ahead.
I want to just let thank everybody that's here today. It is a full room. And I know it's very hard for some of these residents to come forward because a lot of them are scared. Right. And I appreciate their bravery. And I hope that what we do here tonight allows some of them to sleep at night today and to understand that at least they will have a home. At least we hope that that's going to be the result of today. And I wanted to let them know that this is a safe place for them to come. We might not have the answers. They might not like to hear what we have to say, but I think that we've really come a long way of being transparent and allowing our residents to know that we're not perfect. We're going to continue to do good work here in Oxnard. We're going to miss some staff, but it's really up to them to come and let us know where it is that those flaws lie.
Thank you.
I want to thank staff. If you look around the front of the room, you have 3 attorneys, you have Amelia, you have community development, you have our administration. It takes a lot of people to do this in a very, very short time. Your effort does not go unnoticed. Thank you, thank you, thank you for serving Oxnard, for serving the population that really is underserved. And I greatly appreciate the entire effort that you have all made. Emilio, to your staff, I've heard wonderful things about them. The young lady in the back and the young man in the back, I've never met you, but I know that just from talking to Cause, they had a lot of good things to say, and
That's right.
I greatly, greatly appreciate it. And this is the work that we're here to do. We're public servants. We're here to serve. And from the bottom of my heart, with a lot of gratitude, thank you.
Thank you so much, Councilman Madrigal. Oscar?
I should have spoken before Councilwoman Basula, but no matter what I say, it's not going to be better than that. So I'll just leave it
You'll
at
second
that.
it?
I'll just second it.
I also, want to thank, our staff, and I want to thank Maria, because she called me earlier, and to thank, our city manager, our city attorney, our assistant city manager, and our staff, our assistants, for the good work they've done. And really, I want to thank all the folks that are here, and as the Councilwoman mentioned, don't be afraid. No tengan miedo de venir a hablar con nosotros. Thank you so much for being here tonight. And thank you and this is really important because it was shared by somebody that half of the people that are being evicted are children. And we have a major problem with homelessness issues here, and I think that this ordinance will help us, potentially alleviate some of the concerns and trauma that our residents are experiencing. So thank you for being here tonight, and thank you, Maria, for calling me earlier, and I thank you for that. So, Mayor Pro Tem,
Excuse me, Mayor Zaragoza.
we do have somebody?
We have Barbara McCreary.
Okay.
She's virtually online.
Okay, let's go ahead and get Barbara. Thank you.
Barbara, you have 3 minutes. Please press *6 to unmute.
Good evening, Mayor
evening.
Zaragoza and council members.
Mm-hmm.
I am really very grateful and pleased at the initiative of the city. This ordinance, and particularly as an urgency ordinance, is critically needed. And, since we passed the ordinance back in 2022, I've seen all the different ways that some unscrupulous landlords try to evade the law for their own purposes and kicking people out without a second thought. Our housing supply is critically, we're just in a real critical state because when I work with tenants on these types of cases, in the ones where we can't keep them in the homes, they're losing their rights to live in Oxnard. And in some respects, they're losing their rights to even live in California. I had a client in one of these types of cases a couple of years ago. And this is one where they avoided our ordinance by rushing it through before the June 3rd effective date. And that tenant ended up in Tennessee, telling me that they can't even afford to live in Bakersfield anymore. I mean, we have a desperate, desperate situation. And so I think this is really a good start. It gives me some tools when I'm out there representing people. I come from the days where tenants had no rights at all. The only right they had was to process. And the only way you could beat them is if they messed up the process. So it's really heartwarming to me that there is finally a recognition that tenants have rights too. And I think this ordinance, you know, they try, some landlords, I would say a lot of out-of-towners, out-of-staters, you know, they find every which way to skirt the
30
the
seconds.
law just to get their way. And this is really a public service endeavor, I think, that you're making, and it's for a modicum of protection for the tenant community, and I'm very appreciative of it. And I hope this passes, and then we can take some of these into court and win these
Thank
cases.
you. Thank you, Barbara. We have a comment
Thank
for
you.
Councilor Valenzuela, and then we'll go with, any other speakers?
Mayor Zaragoza, there's no additional speakers.
Okay, Councilor Valenzuela wants to make the statement, and then we'll go with the city manager. Go ahead, Councilmember.
Yes, I had one more question. I'm not sure if this is for housing or the city attorney, but I guess theoretically for any, if the urgency ordinance was to pass, I guess would any eviction notices that were given to tenants, would they have to restart the process tomorrow or effective immediately with new eviction notices with plans for permits?
Jason, or go ahead.
Yes, happy to answer that. It depends on the forms of the eviction notices. Right now, housing and the city attorney's office are working together. We believe that there are some deficiencies, so assuming the council adopts this tonight, then by tomorrow we'll make a determination, and if we find that they are deficient, then notices will go out.
Thank you.
Thank you, good point. City manager?
Thank you, Mr. Mayor. It's just a couple points, because we did stray into the variable hypotheticals tonight, so I just want to clarify a few things. Our staff is, as they mentioned, it is case by case where we would have to evaluate. But something caught my attention with Councilmember Perello's hypothetical, which is if they're starting with a non-substantial project such as carpet replacement and they were to discover black mold, and then that triggers a substantial renovation, but the issue here is that is a health and safety and habitability issue. That is not a improvement to make the place nicer issue. So while that may trigger, hypothetically, a substantial renovation, it also may not allow them to evict based on that. So I just want to be clear, there are lots of nuances here. Now, with regard to all the families here and the cases that we are now interviewing, and we will obviously have to engage with the owners, depending on where the evidence leads, and again, hypothetically, it may need to be elevated. So in the city, we have the city attorney, but in the county, there's also the district attorney, and in the state, there's the California Attorney General. So depending on the nature of the evidence, as you go higher up, the consequences are much more severe than what we can ever do as a city. More than a year ago, I did speak to the district attorney about the potential for these kinds of cases. And again, depending on where the evidence leads, we might have to push it to them to prosecute if necessary, and if for whatever reasons they don't, then I would certainly formally request the Attorney General to intervene. Thank you.
Good point. Any other comments? If not, council members, I need a motion. Motion, Duran?
Well, I had one more thing, but I think,
I didn't see your- I didn't see
I
your-
heard a motion earlier during Councilor Valenzuela's,
That's when it's
at the end of his comments.
You want to make a motion, or you want to share additional information?
Just a quick thing, just for clarification for the public, for staff here, I alluded to it in my comments. We certainly rely on reporting from tenants when they suspect or they feel that there is non-compliance with our existing ordinances or their rights of as tenants or the obligations of property managers or landlords. And Councilwoman Basua said it great that, please don't have fear, don't feel that you can't come to the city because our housing department, our community development folks, our city attorney's office, they are in place to do a number of services. One of those services, as codified by this council, is tenant protection, as is listed in that ordinance. This is another item or another layer to that to add protections for our tenants. And so I hope that those listening now, those listening tonight, will hear that and know if you believe that there's wrongdoing happening or that a landlord or property manager is not acting in compliance with what they're obligated to do, please report that. I cannot stress that anymore. We need to hear that information, because otherwise it goes unsaid, and these types of situations where someone may be evicted unlawfully or unjustly are allowed to occur and then reoccur again and again. So I just wanted to take the opportunity to remind folks of that.
Just before we go on the motion, I just want to add a little bit to that. What department do they call if they have a concern? Is that the housing authority? And you want to give them a phone number for that? And I think that's important, because otherwise they're going to call us,
We'll announce your cell phone.
38574. Emilio, just go ahead and give them the phone number in español, in inglés.
Oh, en español también? Okay, cool.
El número, si necesitan una queja, si tienen queja o quieren Emilio es la persona del departamento que pueden hablar. Emilio is a department you can call in case of a concern. Go ahead, Emilio.
You said it well, Mayor. By all means, we encourage that they call us as soon as possible. The clock ticks and we need to start working as soon as possible. So they should call the housing department. Even if they're not sure that there is a violation, call us and ask, and we can determine and investigate and determine if there is a violation and help go forward. It's not, don't be concerned that it's going to be a waste of time. We'd rather assess and figure out there's no violation than be too late. So call the phone number 805-385-7899. That goes directly to the staff that would receive the rent control or the tenant protection violation complaints.
One more time slowly. What's the phone number?
805-385-7899.
En español.
And in Spanish. Okay, cool.
385, sí, go ahead.
What he said. Okay, cool.
Go ahead, Emilio.
Primero, necesitamos que la gente nos llame inmediatamente, porque empieza el trámite de investigar y tenemos que terminar esta investigación antes de que se dañe el inquilino. Así es que, por favor, llámenos inmediatamente. El número de teléfono es el 805-385-7899.
You see?
Gracias.
You're a good man. Okay, motion. Thank you, Emilio. Motion, Valenzuela. Do we second? Second. Masua.
So, Mayor,
Yes,
would
sir.
like to just read again the recommended action so that the motion is for. So first, to adopt an urgency ordinance entitled An Urgency Ordinance of the City Council of the City of Oxnard amending Section 27-4 of the Oxnard City Code regarding no-fault just cause evictions occurring as a result of a demolition or substantial remodel. 2, approve the first reading by title only and waive further reading of an ordinance titled An Ordinance of the City Council of the City of Oxnard amending Section 27-4 of the Oxnard City Code regarding no-fault just cause evictions occurring as the result of a demolition or substantial remodel. And 3, find that these ordinances are not subject to the California Environmental Quality Act under State CEQA Guidelines, Section 15060, Subdivision C2, in that these ordinances will not result in a direct or reasonably foreseeable indirect physical change in the environment, and are further and independently exempt from CEQA pursuant to Section 15061, subdivision B3, in that it can be seen with certainty there is no possibility these ordinances will have a significant effect on the environment.
Thank you, that's clear. So, Madam Clerk, we have a first by Councilman Valenzuela, second by Councilman Basua. Please vote.
Motion carries 7-0.
Thank you so much, and we are adjourned. Thank you. But you voted for it?
Yeah.
Valenzuela voted for it.
Yeah.
The light didn't go on, so. So that's 7, right?
Can you please revote?
Okay, let's revote real quick. Or
Thank you.
go ahead. Please vote for the item. It's not working, but he voted yes.
I'm going to do a verbal
Yeah.
verbal
Roll
vote.
vote, okay, go ahead.
Okay. Councilmember Tehran.
Yes.
Councilmember Basua.
Aye.
Mayor Zaragoza.
Yes.
Mayor Pro Tem McDonald.
Yes.
Councilmember Madrigal.
Aye.
Councilmember Perrello. Yes. Councilmember Valenzuela.
Aye.
Thank you. Motion carries 7-0.
Thank you, that's passed. Thank you, gracias. And we are adjourned.